You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to season 3 of Based in Fact, a true crime podcast. We are your hosts, Lisa O'Brien and Kyle Evans, and this is episode 3, State of Tennessee versus Janet Elaine Hinds. In 2019, Hinds was charged with vehicular homicide by intoxication as a result of striking and killing Nicholas Galinger, a police officer with the Chattanooga Police Department, on the night of February 23rd, 2019. Hinds was also charged with reckless driving, leaving the scene of an accident resulting in the death of another, failure to report an accident, failure to render aid, violation of a traffic control device, speeding, failure to exercise due care, failure to maintain the appropriate lane, and DUI. We'll talk about the case against Hinds, whose conviction was affirmed on direct appeal in August of 2023. All right. Good afternoon, Kyle. Welcome back.
Good afternoon. How are you? I'm looking forward to this case. A little bit different flavor, but I think it'll be really interesting.
Yes, I think it will be. So this is a case with a social message, and that is that no matter how good you think you are, when you drink and drive, there's the potential to take someone else's life and ruin your own life. And I think that's
Yeah.
the lesson that hopefully Janet Hinds has learned, and hopefully others have learned it as a result of her experiences.
Yeah,
So,
absolutely. I mean, yeah, so much can change your life just a blink of an eye,
hmm yeah.
especially
Um,
when you've been drinking as much as she was.
right. And she did. We'll talk about that a little bit later. The victim in this case is Nicholas Scott Gallagher. He was born on June 22nd, 1980 in Cincinnati, Ohio. His parents are Barry and Gretchen Gallagher. He has four siblings, Tanya, Tiffany, Barry Douglas, and Brent. He was a graduate of Claremont Northeastern High School in Cincinnati. He also attended DeVry University and was a graduate of the Chattanooga Police Academy in 2019, which was unfortunately about a month before he was killed. He was a police officer in phase one of his probationary period, which was comprised of 6 weeks of training with a field training officer. Then you go to phase two and you go to training with another officer, and there are four training phases. He has two children, or leaves behind two children, Ethan and Haley. His injuries were multiple blunt force injuries resulting from a collision with a motor vehicle, including vertical incised wounds and irregular lacerations and abrasions on his face, a crushing injury and fractures on the back of his head, fractures of the thin layers of bone above his eye sockets, fracture of the cervical spine at levels C4 and 5, located halfway down his neck, fracture subluxation of the lower thoracic part of the spine where the chest and lower back meet, laceration of the aorta, dislocated left shoulder, abrasions and contusions on his hands, two fractures of the right femur, fracture of both the tibia and fibula of the left leg, and multiple irregular abrasions on his knees, lower legs, and feet. And those injuries are consistent with them being standing and struck by a vehicle. Um, so the allegation was that he was kneeling down, but those he wouldn't have had those injuries to his lower legs or his
Right, so
legs
he was probably standing up.
if he had been kneeling. The injuries would have been probably, first of all, confined to his upper torso and his head. Um, and he wouldn't have also been thrown. He was a lot of the injuries he sustained were also from being thrown over
Mm,
the vehicle,
right.
which we'll get into a more detailed description later.
Now, was he married at the time? I know I see the two children, but was he
I
married
did
at the
not see
time?
anything about a marriage or a spouse or a former spouse. Um, I don't, but I didn't find anything that, he was. It appears that his children are living with his parents or members of his family. So I
Got
don't
it.
know whether he was a single father because their mother left,
Well,
was deceased, was
yeah, and
not capable.
preparing for the case, I did read a few articles about him, and I did kind of get the impression maybe his life had taken a little bit different direction, and maybe he was really getting his life back on track. I know some of the things that his
Hmm.
sister said kind of made you think that maybe he had not all because I think what, right, if I do my math correctly, he was what, 29, and so it's a little bit older to be,
Right,
a
right.
new police officer. So
Yeah.
it did
And
sound like maybe he had some wayward 20s before he kind of got his life on track. So
and DeVry is a computer science technology
right.
school. And I did read another article that he did like to design games or do design work for games. So it may be that um he he did that in his younger days, but it wasn't lucrative enough for him, or it didn't really satisfy him. Um and there are a lot of articles that say his dream was to be a police officer. So I'm going to say that he finally decided to go live the dream
Right.
and changed his life to go, and he went down to Chattanooga and attended the academy and graduated from the academy. So, but there is a bit of a mystery as to that earlier life, and it just isn't there. And maybe because he had moved on
Right. Yeah, he
and
may
his
have.
family had moved on, so who he was before was not something they felt the need to dwell on.
Right. No, that makes sense.
So, our perpetrator in this case is Janet Elaine Kirk Pugh Hinds. She was born March 1st, 1964. Her parents are W. Clifford Kirk and Ruth Kirk. She has a sister named Cindy. She was married to, I'm presuming, Mr. Pugh at one point, and they have a child together, Justin. And then she was married to John Hinds, and they have a child named Jared together. They were divorced, and she was a single mother of two children. She had started working for the Postal Service in the 1980s and had been with the Postal Service for more than 30 years. And at the time of this incident, she was the Soddy Daisy, Tennessee postmaster. Um, I suspect that she was a functional alcoholic only because her daughter-in-law said she drank every day, and also the fact that she was driving like it was nothing.
Right.
Um, and her victim, of course, is Nicholas Scott Galinger. The accident happened on February 23rd, 2019, and it's really strange because I've heard that it was Friday night. I've heard it was Saturday night. She turned herself in on Monday morning. And there's a little bit of confusion in the narrative about what day of the week it was. Um, and on the evening of the 23rd, Hines spent the evening at a restaurant and live music venue in Ringgold, Georgia, which I think is probably just south of Chattanooga, with her parents, son, and daughter-in-law. During the hours between, or her daughter-in-law's parents, it wasn't really clear. Um, anyway, during the hours between her arrival at 6:43 p.m. and departure at approximately 10:33 p.m., Hines consumed 76 ounces of beer, which involved two 16-ounce glasses of beer and two 22-ounce glasses of beer, and a lemon drop shot. It had been raining in the area for several days. Hines' daughter in law offered to drive her home because of the weather and the fact that Hines had been drinking, but Hines declined and chose to drive herself home. Due to the heavy rains, a manhole cover on Hamel Road had come loose and had been bubbling water into the roadway for some time. Again, there's dispute whether it was several days or that day was the first day. And those of you who don't live in a rainy climate with poor drainage work infrastructure, um, I see this a lot in New Orleans, especially downtown.
Right.
When we
Yeah, you
get
get that.
concentrated heavy rain, the manhole covers in the middle of the street start bubbling up. Uh, Sometimes the sewer traps on the side of the road will start bubbling up. And we had one case when I was at personal injury firm against the Sewage and Water Board because somebody was walking from the street across the easement and the cover of the trap had become loose and was no longer there, and they thought they were just stepping in a little shallow puddle of water, and they went into the side trap for the drain because the cover was gone. And it's a big, it's those big metal rectangular metal covers. It's not like a little, manhole. People used to steal the manhole covers because Sewage and Water Board has a really good design, a nice design on them. But anyway, it's something, and also, um, from my personal experience and knowledge, a manhole cover that has become dislodged can mess up your car like you wouldn't believe.
Oh yeah, absolutely. Well, then, yeah, the manhole cover could fly up, or you drive over the open hole.
Yeah, if you drive over the open hole and one of your tires goes in that open hole, you're probably going to bust your axle and total your car, unless your car is worth $50,000.
Right.
So it's not a trivial situation by any stretch of the imagination. The area had initially been marked with an A-frame barricade with a broken light. If Hines had taken this route on her way to the restaurant, which I believe that she did, this is an issue she should have been aware of as it had been going on, if not just that day, for several days. And from what a lot of the statements and a lot of the things that I found, she took this route on Hamel Road frequently. At the beginning of their shift, Officer Galinger and his FTO, Officer Jared Justice, were dispatched to Hamel Road due to the dislodged manhole cover. The area was lit by a street light, so Officer Justice elected to park at a nearby driveway and not to risk distracting drivers with blue lights at the side of the road. During the 5 to 10 minutes they were at the scene, multiple vehicles were able to slow down and navigate around the barricade and through the area without incident. Hinds, due to her impairment, was not driving carefully. During her trip home, Hinds had received a call from her daughter-in-law warning her of an accident on her route. Hinds texted back that she was able to avoid police at that location, but she was also likely anxious to get home and was likely looking out for more police. According to Officer Gallinger's body camera, Hinds was traveling at a high rate of speed in the center of Hamel Road as she
Mm.
came out of a curve. She struck Officer Gallagher, propelling his body over the
Yeah.
hood and roof of her car and 160 feet behind her vehicle. The grill of her vehicle was dislodged, and there was a hole in the windshield caused by the impact with Officer Gallagher's head. Hinds stopped briefly, then fled the scene. Officer Gallagher had sustained internal injuries, multiple broken bones, and severe head injuries. Despite CPR performed by Officer Justice and efforts by multiple officers, paramedics, and medical personnel, Officer Gallagher died of his injuries at the hospital. Between 11:30 and 11:45 p.m., Hinds called her daughter-in-law to report that she'd struck a road sign and asking for a ride to a family event they planned to attend on Sunday. The following morning, Hinds' daughter-in-law saw a news story about Officer Gallagher and contacted Hinds, who then disappeared and contacted an attorney. Hinds left behind the grill from her 2017 Honda CRV, which was used to identify the make and model of the vehicle. Officer Gallagher's body camera and Officer Justice's eyewitness account showed that the vehicle was white or light colored. An officer patrolling in the area later found Hinds' vehicle parked in front of her house the following day. Efforts to contact the residents of the house went unanswered. And she had a garage, and I'm wondering why she wouldn't have parked the car in the
I
garage.
thought the same thing too. That's really strange that she left it out
Because if she
front.
had done that, then they would have never found the vehicle.
I mean, it's kind of strange. It almost makes you wonder, was she really that out of it? Maybe she actually didn't realize she hit. I mean, it seems impossible, but that she wouldn't know
Well,
she hit a person, but it is odd
I
she'd leave the car out front.
I do not buy that she doesn't know she hit a person because there's a hole in her windscreen or windshield, and
Yeah.
the injuries to Officer Gallagher's face, their accident reconstructionist believes that for a few seconds his face was in the windshield and there was part of his scalp found inside the car.
Oh,
So how she could not know she struck a person, I don't believe it. I believe she says I didn't know because she thinks it absolves her of liability or culpability. But I believe that if you think you just struck a sign, you don't drive away.
right. No, that's exactly right. Especially if you have a hole in the windshield. Yeah, exactly. If you
Correct.
think you hit a sign, you just stop and
You
make
stop
sure
and
your
you go
car
and
is
look at the
drivable.
sign and you call the police and say, God, what was the sign doing in the middle of the road? You know, but she didn't. I think she knew that she'd struck a person and so she fled. And then she
Yeah, I
started
think
telling
that's
people,
right.
I hit a sign, I hit a barricade. And then when they told her, no, you hit a person, she took off.
Yeah,
And
no, I think
they
you're
couldn't
right.
find her for 2 days. Um, while Hinds eventually turned herself in, she did so on Monday, 2 days after the crash, and only after being placed on the TBI's 10 most wanted list. This is likely because Hinds didn't want to be inconvenienced by having to remain in jail until Monday. Um, and probably so that she could let all the alcohol get out of her system so that they couldn't prove that she was intoxicated at the time of the accident. Because that's also the only other reason to flee.
Right. Yeah, she knew she was hammered.
And I'm going to go out there. She fled. If you hit a parked car, if you hit a sign, if you hit a house, if you hit a person, if you drive away and don't contact police and at least make an effort, because I know some jurisdictions, police don't come out for stuff like that. But if you don't at least make an effort, then your intent is to try and get away with it. And I'm guessing that if she hadn't been found, she would have gotten the damage to her car repaired and paid cash, or she would have tried some kind of insurance scam. Either by saying the car was stolen, or and I'm not entirely certain that didn't run through her mind to say the car was stolen.
Yeah, that would have. Yeah,
You know,
I'm still surprised she didn't. If she had it, maybe her garage was full of junk.
that may very well be.
But I am surprised she wouldn't have pulled it. She would have left it on the street, not at least pulled it in the driveway.
Yeah. Well, or she thought she was far enough away from the scene that nobody would ever find it, because it's in a quiet residential. She's in a quiet residential neighborhood.
How far away is she? No, it's her address. That one on Post, is that her address? That
Her address is
Port
on Port
Port Drive.
in Hickson. And
Got it.
apparently, yeah, as I understand it, if you go in the direction she was traveling, there's a street called Cassandra Smith. You turn on Cassandra Smith, I'm not sure which direction, from Hamill Road, and that goes into the subdivision where she lived. So that is probably
Yeah, so
that
a
is
little bit, because
probably
according to the map, it looks like it's about 5 miles away between her
correct.
house and the scene of the accident.
Correct. And I have to hand it to Chattanooga police, because they did. I mean, I guess they had officers just driving through. They knew they were looking for a Honda CRV. They knew it was light colored or white, and that's what they did. They drove around that area in that radius looking for that vehicle and found it. It's like a needle in a sack of needles.
Yep.
So a warrant for a search of her vehicle was issued on February 24th. That was actually executed after she was arrested on the 26th. Another warrant for the residence was issued on the 24th. I'm guessing that was also probably executed on the 26th, but I don't have the warrant to see what date the execution was. And then there was also a third warrant for blood alcohol that was issued on the 25th and executed on the 27th. Hinds retained Benjamin L. McGowan as counsel. The state of Tennessee was represented by the Hamilton County DA, Neil Pinkston. Hinds's bond was initially set on February 25th at $300,000. On the 27th, they filed a petition for writ of supersedeas to reconsider bond amount and conditions. A preliminary hearing was held on the 5th of March. The case was bound over to the grand jury, and her bond was reduced to $100,000 with house arrest, ankle monitor, random drug screens, and surrendering her passport and driver's license to the criminal court's office. So, criminal court clerk's office, so she couldn't drive. She was allowed permission to work, and they waived violent offense, which would have made her bail higher. On March 19th, 2019, Officer Galinger's family did file a lawsuit against Janet Hinds, as they should. They also, on the 20th, sent a letter to Farm and Fork, which is the restaurant where Hinds was the night before, and they basically wanted them to putting him on notice and seeking preservation of potential evidence. She was indicted formally on April 23rd, 2019 for vehicular homicide by intoxication, reckless driving, leaving the scene of an accident resulting in the death of another, failure to report an accident, failure to render aid, violation of a traffic control device, speeding, failure to exercise due care, failure to maintain the appropriate lane, and DUI. She was rearrested on the 23rd after the indictment. and she bonded out with payment of an additional $7,500. That was all on April 23rd. On June 28th, 2019, she failed to call or show up for a random drug test. And then the next day, I believe, she contacted and went in for the random drug test, which was positive for alcohol. So her bond was revoked.
Mm. Well, and I mean, not to take away from what she did, but these are the things like in my head doesn't show a lot of contrition. Like I feel like if
Mm-hmm.
she's truly contrite, she's not ever drinking again. She's like,
Yeah.
okay, my God, I killed somebody. I'm quitting today. And
Yeah.
the fact that she just doesn't even show up for her her random test. I mean, she knows she's subject to it. I mean,
Mm-hmm.
it shows she's not as contrite as she may act like. Or otherwise, she would be dotting all the I's and crossing all the T's, knowing, my God, the one thing
I
I can do is penance, is at least the bare minimum I can
yeah.
do is do what the court is asking me to do.
I totally agree. And her argument, what or her attorney's argument, was that she didn't consume alcohol, she consumed fermented foods,
Please.
or
But
the alcohol tests are all wrong.
once you have 40 pounds of sauerkraut, I mean, come
Yeah,
on.
I mean that was
The dog ate her
the
heart.
argument. Yeah. Yeah, and that was his argument. And he said the tests were wrong, that it was
No,
a
because
false
if they
positive.
she knew she was drunk, that's why she didn't show up. I mean,
Correct.
you missed
Correct.
the first. I mean, she didn't take it. That's why she. I mean, and can you imagine how much she's been drinking if she missed the test and was still
Mhm.
positive the next day?
Mhm. Yeah.
I mean, that wasn't like she had a glass of wine.
Yeah. So then she bonded out on July 11th, 2019. She had to pay an additional $175,000, and the condition of weekly drug and alcohol testing was added to her conditions.
And I mean, I'm
Whereas,
curious too. I mean, no offense to the postal service, but I mean, that's a lot of money for a postmaster of a tiny little town in Tennessee. I mean,
um,
that's a ton.
she had 30 years with the Postal Service, so I'm guessing she probably had a significant retirement pension
Right, yeah, that's
package
fair. That makes sense.
that from which she could probably have gotten
Borrowed against or gotten
money. Um, I think that she also with the property that she owned, the house, she
put that
would
up
have
for
had a
collateral.
property bond, would be pretty easy.
Yeah, that's fair.
So, and if she shows up to all court
She'll get most of it
dates,
back.
it comes back.
Right.
So, um, and she had retained counsel. So she has money, or her family has money, or her parents have money, or all of her friends and neighbors helped her out.
Right.
So Galinger versus Hinds, a stay was issued on November 7th, 2019. During the course of the stay, just to keep everything together, the complaints were amended on February 10th, 2020, March 12th, 2020, and March 10th, 2022. And that was to add additional defendants, including the city of Chattanooga, Chattanooga Police Department, and I believe Farm to Fork. Although I only have a copy of the second amended complaint, so I can't speak to, what order, and that was adding Farm to Fork and insurance companies for the various defendants. Um, in the event that Hinds does not have significant assets, or
Right.
or because her auto insurance is not significant enough
Not
to
gonna take care of it.
compensate. Yeah. Pretrial went to Hamilton County Criminal Court. The bond in Tennessee is in General Sessions Court. And then it went to Hamilton County Criminal Court before the Honorable Judge Don Poole. Hinds did file a motion for change of venue on February 3rd, 2020, which was taken under advisement. An initial scheduling order was issued in July on the 13th, setting deadlines for evidentiary motions, pretrial conference, and a jury trial in January of 2021. That did not go forward. On August 28, 2020, Hinds filed motions to suppress the blood testing, the search of her residence, and the search of the vehicle, all of which were ultimately denied by the trial court. On the 7th of December 2020, a new scheduling order was issued, moving the trial date and the pretrial deadlines into 2021. That trial was jury trial on July 19th, 2021. I could not find why that didn't ultimately happen, although, so I can only speculate. What I think may have happened is they convened for the jury trial on the 19th of July, and they were trying to pull jurors from Hamilton County. Too many jurors were familiar with Hinds, Hamilton, Galinger, Chattanooga Police Department, Public Works, et cetera, and so they were unable to find a jury that could be fair and impartial to both sides. And so they the judge then elected to pull a jury from Davidson County near Nashville and bring them to Hamilton County to sit on a jury for Hinds's case, which is what was ultimately done. That trial, jury selection began on September 16th, 2021 in Davidson County. The counsel for the state was Neil Pinkston and Cameron Williams. The attorneys for Hinds were Ben McGowan and Mara Schalk. Jury selection again began the 16th. Trial began on the 20th of September and concluded on the 23rd. The jury deliberated for 15 hours from the 23rd to the 25th and then came back with a verdict on the 25th of September, finding Hinds guilty on counts 1, 2, 3, and 4, which were vehicular homicide by intoxication, reckless driving, leaving the scene, and failure to report an accident. Then counts 7, 8, 9, and 10, speeding, failure to exercise due care, failure to maintain the appropriate lane, and DUI. They acquitted her on the failure to render aid and violation of a traffic cone control device, counts 5 and 6.
That's
Her
surprising,
sentencing,
the failure to render aid. That seemed like one of the more obvious ones.
well, they probably, because Officer Galinger was not there alone and Officer Justice and responding officers were there to administer aid to him, perhaps they didn't find that her leaving the scene was a factor in
his
his.
And what
Well,
were I was curious. Oh no, go ahead. I'm sorry.
she didn't render aid. She didn't call for help. And if he had been there alone and nobody had been around, they would have convicted her.
Got it. And on the DUI, did they just use, I guess, testimony from folks that saw her at the bar? Because again, it's that she didn't turn herself in for what, 3 days? So I guess, is that how they just sort of put that together, I'm assuming?
During the trial, I guess a toxicologist, I'm not sure what his position was with the Tennessee Bureau of Investigation. He observed, there was video from Farm to Fork showing her in the restaurant, in the bar, drinking, whatever. And so he was able to observe that video, calculate her weight and the amount of alcohol she consumed, and come up with estimates of her blood alcohol content
Right.
at the time of the accident.
Gotcha.
So, and that was a factor in her appeal, which we'll talk about a little bit later. On the judge set the sentencing for November 1st, 2021, but then on October 4th, 2021, Hinds had to undergo, quote, open heart surgery. Her attorneys filed a motion to continue her sentencing hearing on the 21st of October due to that surgery, which, according to her doctor, she would be released from care in February of 2022. Her sentencing was then rescheduled on October 25th by order of the judge for February 7th, 2022. Her formal sentencing did go forward on the 7th, and she was sentenced to 11 years on count 1, 6 months on count 2, 3 on counts 3 and 10. She was sentenced to 11 years and 29 days. Counts 4, 7, 8, and 9, she got 30 days and a fine of $465. On the 25th of February, she filed a motion for new trial, alleging that the court erred in denying her motion to suppress the searches of defendant's house and defendant's car. The court erred in limiting cross-examination and excluding evidence regarding the defense calculations of blood alcohol levels during the novel testimony of TBI Director Mark Little, who testified that this was the first time he had ever used this method to extrapolate a blood alcohol level of a defendant. The ruling precluded the defendant from introducing as an exhibit a chart of the calculations using alternative but recognized variables, including providing to the jury the calculations using the Widmark formula with an accurate weight, alternative but recognized row values, and alternative but recognized elimination rates. Now, this was the reason this wasn't entered is because an expert cannot authenticate calculations he didn't do. These were somebody on the defense team made these calculations, and then they tried to present it as an exhibit during the testimony of the state expert. What they could have done is gotten their own toxicologist to come in and do these calculations and testify and authenticate this exhibit. And that's why it wasn't entered. And even if it had been entered, a lot of the values still came up at 0.08 at the time of the accident. So it didn't exonerate. And they also wanted to say she couldn't have had a 0.08 at the time of the accident because when she met with the attorney, she was at 0, according to these calculations. It was just crazy.
Well, and I mean, because I don't know off the top of my head, but I mean, 0.08 is a pretty low bar. Like, it does not take a lot to get to 0.08. So, I mean, 72 ounces, right? 72 ounces, that's definitely going to put virtually everybody over
76.
76. Yeah, that's, I
think it was 76.
That's
plus that didn't count the lemon drop.
That, yeah, right.
Exactly. That calculation was not included. That was 76 ounces of beer.
Right.
And then the lemon drop.
Right.
So, yeah. Some of the other issues raised: the court erred in allowing the videos of Officer Warren traveling Hamel Road to come into evidence because they were taken nearly 2.5 years after the accident during the daytime and under significantly different circumstances than the night of the accident, which was misleading to the jury. The court erred in giving a flight instruction in this case The court erred in its instruction to the jury on proximate cause and intervening cause, and erred in not giving an instruction on these causes as requested by the defendant. The court erred in allowing a life photograph of Officer Galinger to go back to the jury room with the jury during their deliberations over the objection of the defense. They didn't like the photograph because he was in his uniform. That insufficient evidence was presented by the state to prove vehicular homicide by intoxication or DUI. The defendant was denied a fair trial by the combination of all of the foregoing errors, and the court erred in sentencing the defendant by imposing an excessive sentence by not giving enough weight to mitigating factors and relying too heavily on one enhancement factor. On April 28, 2022, that motion for new trial was denied. This case went on to direct appeal. Benjamin McGowan and Maria Schalk continued to represent Hinds. They filed their notice of appeal on April 28, 2022. The record was lodged on August 9th, 2022 at the Court of Criminal Appeals. Appellant's briefing was completed on September 8th, 2022. Appellee's briefing was completed on November 30th, 2022. Oral argument was held on February 22nd, 2023. It was very interesting, although the attorney for Hinds sounded like she was going to cry the entire time. The panel before whom the case was being decided were James Kerwood Witt Jr., Robert W. Wiedemeyer, and John W. Campbell Sr., and they are all apparently from Knoxville, I think. The Court of Criminal Appeals rendered its decision on August 11th, 2023. They found that the defendant would have had sufficient room to drive around the barricade and avoid striking the victim had the defendant slowed down and remained in her lane. Instead, the defendant became intoxicated and drove at an excessive speed while straddling the center line, thus striking and killing the victim. We
Yeah, and
conclude
maybe
that
as a little context, like for folks out there, because like a road can mean a lot of things, but this is not really, I'm not excusing it, but like so people can kind of understand, this is really, even though it's called a road, this is like a rural highway. Like it is a
correct.
2-lane road in the middle of the country where you could, no excuse, but this isn't where there's a bunch of stoplights. Like you can see where, especially if you're intoxicated, you start losing control and really getting going, pretty quick. It's not like this is a surface street where you're gonna hit 30 miles an hour and then you're gonna stop at a red light. It's really like a rule, almost like what we in Texas call farm to market roads.
Yeah. And also it was their it was kind of narrow, and there apparently was no shoulder.
Right. Yeah. It is very narrow. I mean, it would be hard to drive like in the day. Like you'd have to be careful in the daytime, sober, like you speeding, you'd have to,
you need to be
could be
careful
dangerous. You got to
anytime
be
you drive
careful.
this
And
road because it's
right.
not,
Yeah. And there's a bridge right in front
yeah.
of it. It is not in the big curb. So yeah, definitely a place where you need to be extra careful.
And the court went on to say, we conclude that this evidence is sufficient to support the jury's finding that the defendant's intoxication was the proximate cause of the victim's death. Number 2, the trial court's consideration of the affidavit supporting the search warrant for the defendant's vehicle in determining probable cause for the issuance of the search warrant for the residence was proper. Because the affidavit established that the crash occurred the day before the search warrant was sought, the information in the affidavits was not stale, and the search warrant for the defendant's residence was supported by probable cause. The defendant did not challenge the validity of the search warrant for her vehicle. Rather, her challenge to the evidence obtained from the search of her vehicle was based upon her challenges to the search warrant for her residence, which also authorized the search of her vehicle. Because we have upheld the validity of the search warrant for her residence, the seizure of her vehicle was proper, and the defendant is not otherwise entitled to relief regarding this issue. And this is something also that is interesting and kind of ties in a little way to another case. Here we have a vehicle involved in a crime parked on the driveway on a public street, and yet did the cops just start searching it? No. They got a warrant. And they had to have probable cause. And the probable cause that they presented was challenged by the defendant. And yet again, that explains you can't just search,
Right.
because it would this is the murder weapon, and yet they still got a search warrant because this is a murder weapon. Is not an exception to the Fourth Amendment.
Right. Absolutely.
So, the photograph of Officer Galinger was relevant to show the victim's general appearance while alive and his approximate height and weight. Although the defendant claims that the photograph is prejudicial because the victim was wearing his uniform, the evidence at trial clearly established that the victim was a police officer and was on duty when he was killed. The photograph is not unfairly prejudicial to the defendant. The videos were relevant to demonstrate the layout of the road and the effect of speeding on visibility and reaction time, especially in light of the defendant's argument at trial regarding the dangers of the particular roadway and suggestion of negligence in the placement of the barricade and the lack of signage warning of the barricade. The videos also corroborated and illustrated Officer Warren's testimony regarding the distance of the straightaway after rounding the curve and leading to the crash site. Officer Warren repeatedly acknowledged that the recordings were made under different weather conditions and at a different time of day than when the crash occurred. Although the video from Officer Lockhart's dash camera provided a perspective of driving down Hamel Road shortly after the crash, Officer Warren's videos illustrated the effect of speeding at the approximate speed at which the defendant was determined to be going on reaction time. Accordingly, defendant failed to establish that the videos were unfairly prejudicial, see Tennessee Rule of Evidence 403, and thus the trial court did not err in admitting the videos. The defendant thoroughly questioned Assistant Director Little on cross-examination regarding the alternative calculations. Some of the defendant's own calculations showed a blood alcohol level at 0.08 grams per percent or higher, and thus the jury could have rejected Assistant Director Little's calculations and still concluded that the defendant had a significant blood alcohol level at the time of the crash. Furthermore, to obtain convictions for vehicular homicide by intoxication and DUI, as charged in the indictment, the state was not required to establish the defendant's blood alcohol level at the time of the crash, but was required to establish that the defendant was under the influence of an intoxicant that impaired her ability to safely operate a motor vehicle by depriving her of the clearness of mind and control of herself that she would otherwise possess. The other evidence presented at trial establishing this element of the offense was strong. Therefore, we cannot conclude that any error in the exclusion of the document more probably than not affected the judgment or resulted in prejudice to the judicial process. The state presented the evidence that after the defendant struck the victim with her vehicle, the defendant drove away from the scene. On the following day, when the defendant's family members learned that the defendant struck the victim, they attempted to persuade her to contact the police, but the defendant refused and contacted an attorney instead. Once police officers discovered the defendant's vehicle later that afternoon, they went to great lengths to locate her, but they were unsuccessful. An arrest warrant was issued, and the defendant was placed on the TBI's most wanted list. The defendant turned herself into the police the next morning. The defendant maintains that the issuance of an arrest warrant is required before a defendant can be found to have evaded arrest or prosecution, and that she had no duty to turn herself into the police until the arrest warrant was issued. However, a warrant was not necessarily required to arrest the defendant. An officer may arrest a person without a warrant when the person has committed a felony, though not in the officer's presence, or when a felony has in fact been committed and the officer has reasonable cause for believing the person arrested has committed the felony. Additionally, this court has upheld a flight instruction when the defendant remained concealed and then turned himself into the police following the issuance of an arrest warrant. The defendant asserts she did not have a motive to flee after the crash because she did not realize that she struck the victim until the next morning. She also asserts that her motive for leaving home the next day was not to evade arrest, but to meet with an attorney who then contacted an officer to arrange for the defendant to turn herself in the next morning, which fell on a Monday. And everybody, Miss Hinds did not return to 207 Port Street because police were waiting there for her. So I'd call that fleeing.
Yeah, well, I mean, as you said before, if she had thought she'd hit a sign, she would have stopped to make sure her car was okay and drivable. And I mean, I don't know, I feel like, I mean, she was pretty intoxicated, but I feel like she had to, especially when you said part of his body was in
Yeah.
her car, she had to. Did she stop at all, or did she just keep going straight on?
She stopped and then she drove off. She
Right, so
stopped
she had
briefly
to
and then
know
she
what
drove
she
off.
did. Because I
Yeah,
mean, you said there was a hole in the windshield, correct?
correct.
Now, was it? I'm sorry. I know. Was it raining at the time, or had it stopped raining?
It had stopped raining, but and this is what I say. Her attorney, I'm gonna stop talking about the direct appeal opinion and go back a little bit. This is what I say, and it's my speculation 100%. Come after me on YouTube if you want to. I believe her level of intoxication was such that she was easily distracted. And so she saw that police car off the side of the road. She's
Yep.
just had to avoid police a ways back. And that's what she was focused on.
Actually, I think that's exactly right. I think you're spot on because she knew she was over the limit, and she probably thought it was a speed trap, or he
Ad-
was going to pull her over and freaked out.
Additionally, I believe that Officer Galinger could have been wearing reflective pants, reflective shirt or jacket, reflective helmet with a fucking disco ball providing a spotlight of him, and she would not have seen him because that manhole cover, that barricade, and Officer Gallagher were standing directly beneath a street light. And her attorney argued because he wasn't wearing reflective clothing, she couldn't see him. And her attorney blamed the Chattanooga Police Department and his field training officer, who, as I recall from his testimony at the trial, due to this experience, is no longer a police officer.
Mm.
And I could be mistaken about that, but uh blaming him for not wearing reflective, they weren't there to direct traffic. They
Right.
were there to assess the situation and call the Department of Public Works.
Right.
And they had only been there a few minutes.
Right.
So, I mean, putting on and he criticized Officer Justice for not having his blue lights on. Well, the blue lights on the side of the road are distracting.
Right.
And again, I think she keyed in on the police car.
Yeah, I think you're right.
But again, I believe she was so impaired, if he'd had a disco ball and a spotlight on him, she wouldn't have seen him
Yeah, well, no, you're right because I'm looking at it on, you can see it,
until his
there on.
face broke her windshield.
Yeah, that's right. Yeah, no, you're exactly right. I mean, the manhole cover is right by a street light. Now, I don't know how
Mm-hmm.
powerful it is, but it is a street light that's there on the electrical on the power pole.
Mm-hmm.
So, but I think, yeah, I think you're right.
It
I think she knew she was intoxicated. She saw the car, and she was probably watching that to see what was happening, to see if he was shooting, whatever. If he was going to pull her over, she was distracted by that and probably didn't
Mm.
even notice officer in the middle of the road.
No, or the sign. And if they hadn't been there, she probably would have barreled over the sign. One of her tires would have gone into the manhole, or she would have, almost barreled into the sign and then corrected, and then, tire go in the manhole and crash the car. If only she had been the only one hurt. But again, they weren't even there that long. And Officer Justice did not know why Officer Galinger went back. They had both gone out. They assessed it. They came back to the side of the road. Officer Justice went to the car. Officer Galinger went back to the road. They think maybe a part of the sawhorse barricade had been knocked down, so he was picking that up.
Yeah, and I mean, he's a young cop. He's eager out there to help. He's,
Yeah.
still on probation. He's
Yeah.
eager. It's all wanting to help people and go out there and make it better.
So, but whatever it is, it's not his fault. He was doing
No.
his job.
Right.
And she's the one who was drunk, and she's the one who was driving too fast for road conditions.
Exactly. Well, yeah, exactly. Yeah, because looking funny enough, the University of Tennessee at Chattanooga has a chart, and yeah, I mean, she was probably pretty close to double the legal limit. If
Mm-hmm.
I mean, she might have fallen a little bit depending on how long, but you know what, a little, 7 drinks in that amount of time, she
Yeah.
was almost at, over 0.15.
Yeah. And it was she left the restaurant at 10:30, and this accident happened right around 11 o'clock, maybe 5 after, 10 after 11. So,
Right.
she wouldn't have lost that much blood. And I saw a comment on Twitter. I never found anything official, but she had apparently had a gastric bypass.
Mm.
And that can affect the body's ability to process alcohol
Yeah. Oh, yeah, absolutely. That can really, yeah, I've
and the
known some friends that have
concentration of
had it,
alcohol
and
in
it,
your system.
right. Yeah, your food and everything. Absolutely.
So, especially that much alcohol.
Yeah.
So,
Well, and I mean, again, not, even thinking about it, that she violated her probation and was, skipped.
mhm.
Even when she was told not to drink and was on probation, she was still drinking and
Yeah,
skipped her,
yeah.
uh, blood
Skipped
test,
the
or I mean,
test,
her,
said, "Oh,
drug
I
test.
sorry, I forgot.
Right.
It slipped my mind." And then, yeah. So, and I got to say, I mean, I would want an attorney to help me get a single felony instead of 10. I would want an attorney to get me something less than a quarter of a century in prison. But I would not want an attorney blaming the victim, blaming the victim's partner, blaming the city, blaming everybody but me.
Right.
And the fact that she sat by and let her attorney make these arguments from the preliminary hearing that she didn't commit any crime and she shouldn't even be here
Yeah. Right. Yeah. She
is
has no.
disgusting.
Yeah.
I would have, and if she really had remorse and she really wanted to accept responsibility, she would have had a plea deal.
Right.
She could have taken a plea deal, a single felony charge, and probably not even served any time or
Yeah. That's.
served a couple of years.
Yeah. That is interesting that she turned that down,
Yeah. Well, I don't know that they offered
or
it.
she didn't even pursue it.
I
Maybe.
I don't think I don't think that they offered because her defense and her attorney claiming they were hiding evidence and they were Brady violations and all kinds of bullshit. in pretrial and in challenging the warrants. It, they weren't. I don't think they. I think they knew she wouldn't have accepted a plea. But I would have told my attorney, I don't want to do this bullshit. I don't want to spend 2 years up to trial. I was in the wrong. I want to make it right. Get a plea. I know I have to do some time. That's only right. I just don't want to do 25 years.
Yeah, that
So,
makes sense.
I may have to do a decade. I accept that. But she's not into accepting responsibility or culpability.
Clearly not.
So anyway, going on with the direct appeal, the proof of alternative motives did not preclude a flight instruction, but created factual disputes to be resolved by the jury upon proper instruction from the trial court. We conclude that the state presented evidence of the defendants leaving the scene of the accident, of the crash, and a subsequent hiding out, evasion, or concealment in the community. The trial court did not err in instructing the jury on flight. Finally, the defendant contends that her charge of leaving the scene of an accident does not warrant a flight instruction and that a charged offense other than leaving the scene of the accident must necessitate a charge of flight for the instruction to be warranted. The defendant cites the State versus Smith, in which our Supreme Court held that a flight instruction does not apply to an evading arrest charge, and that when a defendant is charged with multiple offenses, including evading arrest, the flight instruction must specify that the instruction does not apply to the evading arrest charge. In the instant case, the trial court instructed the jury that the issue of flight was not applicable to the defendant's charge of leaving the scene of an accident. We therefore conclude that the trial court properly instructed the jury regarding flight. The jury instruction was consistent with the instruction proposed by the Tennessee Supreme Court and later adopted as a pattern jury instruction. The jury instruction provided that an intervening cause breaks a natural and continuous sequence of events and that a superseding cause is a defense to homicide, which the defendant, in the exercise of ordinary care, could not reasonably have anticipated as likely to happen. The instruction also provided that the foreseeability analysis focuses on the general field of danger rather than the sequence of events or particular injury. This jury instruction fully and fairly stated the applicable law, and therefore the trial court did not err in declining to provide the defendant's proposed jury instructions. We note that the trial court sustained the defendant's objection and instructed the prosecutor to move on. The trial court later instructed the jury that the statements and arguments of counsel did not constitute evidence. In light of the trial court's curative measures, the length and complexity of the trial, and the strength of the evidence of the defendant's guilt presented at trial, we cannot conclude that the prosecutor's improper comments were so inflammatory that they affected the verdict. And this was the prosecutor on his closing told the jury, you must convict her, which they complained about. And then when he came up for his rebuttal, he said, wow, that was melodramatic, or that was dramatic, about the defense attorney's argument, which included telling the jury what a scapegoat is. So that was what that particular holding was in reference to. The record reflects that the trial court considered all the relevant principles associated with sentencing, including the enhancement and mitigating factors, when imposing the sentence in this case. In our view, the trial court did not abuse its discretion by imposing this within range sentence after thorough consideration of the purposes and principles of sentencing. The defendant argues that the cumulative effect of errors committed by the trial court entitles her to relief. The cumulative effect doctrine applies to circumstances in which there have been multiple errors committed in trial proceedings, each of which in isolation constitutes mere harmless error, but when aggregated have a cumulative effect on the proceedings so great as to require reversal in order to preserve a defendant's right to a fair trial. However, the defendant has failed to establish any error entitling her to relief when considered either individually or cumulatively, and that they affirm the trial court's they affirm the conviction and the sentence. Hinds filed a Trap 11 permission to appeal to the Tennessee Supreme Court on October 2nd, 2023. The state sent a letter saying we object. We're not filing an answer, but if you want an answer, we'll file one. So I called that an answer to the application. That was on October 17th. On January 11th, 2024, the Trap 11 application was denied by order of the Supreme Court of Tennessee. The mandate issued on January 23rd, 2024. On January 28th, 2024, attorneys for the Galinger family filed a motion to lift stay and for a scheduling order. A parole hearing was scheduled per her Tennessee DOC page for February 22nd, 2024, and she is eligible for release as early as March 7th, 2024 per her page on the Tennessee DOC. I checked, and she is still listed as a and current inmate in the Tennessee DOC, and there's no news articles or anything that says parole hearing was held or what the outcome of that hearing might have been. And she has her writ to the U.S. Supreme Court, if her attorneys choose to go that route, will be due on April 22nd, 2024. And that is Tennessee versus Hinds.
That's a very interesting but tragic case.
Yes, it is. And it will be interesting. I am friends on Twitter, X, whatever it's called. I follow the Rose Law Firm, which is the law firm representing the Galinger family. I am going to tag them when I post the YouTube and audio for this episode. And if they have any commentary or any interest in appearing, I certainly will welcome that.
Yeah, it'd be interesting to see if they have any updates or any new information.
Yeah, well, now the personal injury case, wrongful death survival will now proceed now that her conviction is essentially final. If she files a writ at U.S. Supreme Court, then it'll be a little while before they decide whether they accept the writ or not. If she doesn't file a writ, then it becomes final on the 23rd when the mandate issued from the Supreme Court of Tennessee. And they may not file a writ. I mean, if she's potentially going to be released now, I think that they should just settle and let it go.
Because, I mean, right or wrong, these tend to be cases where they tend to probably let her out pretty quickly. She's probably not gonna, what they say, I think a third of her sentence. I mean, she's low probability she's gonna serve much more than that. I mean, it's again, no value judgment, but just the way courts work. If you look at all the people who you're gonna release, probably relatively safe. Although I don't know, hopefully she's a bit in prison, has overcome her alcoholism and doesn't come back and continue to do it again.
Yeah, hopefully. I mean, we'll have to see, but yeah, and likely what's going to happen is the corporate defendant, Farm to Fork, will probably litigate this case for some time. her insurance will probably try to get a settlement. I don't know what the minimum limits are in Tennessee, but they will probably try to work out a settlement that gets her out of the case fairly early.
Right.
And then really probably Chattanooga Police, Chattanooga City, and Chattanooga Police, Chattanooga Department of Public Works probably are not deep pockets, and they probably are not going to have much. And if there is any kind of settlement, the family will wait a long time. If it's anything like municipal litigation I've observed in Memphis and in New Orleans, you go on a list. And they don't budget to pay their settlements and their judgments. You go on a list, and when they have extra general funds, they pay the oldest judgments first. We have a poor guy who for years sat in front of City Hall in a wheelchair. He had a lawsuit against the NOPD and won a several $100,000 verdict in the 1980s or 1990s, and he still hadn't been paid.
Right. Yeah, it's one thing to win, it's another thing to actually get the money.
A block of plaintiffs' attorneys attended several city council meetings where they passed on budgetary discussions for lawsuits, settlements, and settlements. These are settlements. These aren't judgments. These are settlements where they agreed to pay a certain amount of money to plaintiffs to settle their cases and not go to trial. And part of the reason they do things that way is because you can't execute against city or state property to enforce a judgment or settlement. So basically, you just have to wait till they're ready to pay you. And it would be interesting to talk a little bit about those things with the attorneys for the Galinger family.
Absolutely.
But I think their major target is going to be Farm to Fork under Dram Shop.
Right.
So,
and it looks like that's just a local place, right? It doesn't look
it's
like
in Ringgold, Georgia.
Yeah, it doesn't look like it's a big franchise. It's interesting.
No, it is a local restaurant. I think they've added their insurance company, which would probably have a commercial, and this would be a commercial general liability. But it'll be interesting to see. And then also, I think on the 31st of March or the weekend after, we may have a special Selena episode with my friend Jordan. My work daughter, Jordan, actually. Because she's a Selena fan, and Michael and I used to do Selena episodes.
Oh, interesting. Yeah.
So she and I we may record it next weekend. Or the weekend after that. Or, well, no, actually towards the end of March. What am I thinking of? I don't know what time. I don't know what. I don't know when it is. When is it? We just went through Mardi Gras.
Yep. Almost to March. 4 more days.
Yep. I know, because we have an extra day in February. And February 29th, 1988, I broke my right ankle. Or my left ankle at work. And so I'm not sure I want to go to work that day.
There you go.
And a couple of other leap years, I've managed to stay home. So, but I'll wait and see what I do. All right. Well, I think that's it, huh? I think we're done.
No, great job.
Thank you.
Have a wonderful week.
A wonderful 2 weeks.
Yes, wonderful 2 weeks. We will talk to you in a couple of weeks.
Yep. All right. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 weeks for episode 4, State of Oklahoma versus Scott Eisenberg. In January of 2023, Eisenberg was executed for the 2003 murders of AJ and Patsy Cantrell in Depew, Oklahoma. We'll talk about the facts of the case, the trial, direct appeal, and post-conviction proceedings, and arguments by Eisenberg and his advocates that Mr. Cantrell was responsible for his wife's death and Eisenberg was acting in self-defense when he killed Mr. Cantrell. Until then, have a safe 2 weeks and stay safe. Good night.
Thank you.